Gonna.
Hello, everyone. This is David Schulman. I'm here with my partner, Jill Ginsburg. We're Ginsburg Schulman, where we specialize in estate planning, probate, trust administration, elder law, and guardianship. And this week, we're going to talk about the guardianship of a minor's property. In our last video, we spoke about the guardianship of incapacitated persons. But if you're a minor, and if a minor is a person who's under 18 and either inherits or receives in a lawsuit a certain amount of money, then a guardianship of their property is required. Jill, why don't you talk a little bit about that?
Well, with the guardianship of the property for a minor, obviously, a lot of parents say to me, but, I'm the guardian. Yes, for the guardian of the person, there will not be a guardianship. You obviously are able to make decisions for your children when they are under 18 years old. Come back and talk to us when they're over 18. But when they're under 18, for property, if they inherit property, or if there is a settlement or some type of lawsuit, then if there is a settlement or property or inheritance greater than $15,000, you will need a guardianship.
And what does that entail? What does that entail? What's the process? How does that work?
Okay, so the way that a guardianship works for a minor is the parent or whoever, the guardian, the person responsible for that child, petitions for guardianship of the child. It is a petition for guardianship. There's also an application, a credit check, and one very important thing, you cannot be convicted of a felony. If you are convicted as a felony, you cannot serve as a guardian, and somebody else will have to serve. You also need to have a good credit score, because obviously if you don't have a good credit score, you can't handle the money for a guardian.
So let's say my distant uncle Ralph passes away and leaves everything to my 10-year-old child and leaves them $60,000. And now my 6-year-old child or 10-year-old child is about to inherit $60,000. What do I have to do?
You will have to petition for guardianship of your child, of the property, and you will petition to put that $60,000 under guardianship. Once it's under guardianship, depending on the county that it's in, you will either need what's called a restricted account, or you will need a bond. And for the life of your child until they are 18 years old, you will explain to the court how much money you spend. You will file an accounting every year. And when they're 18, you will file a discharge.
So even though there's this money, there's this $60,000 in this account, which is for my kid, let's say I want to pay for summer school or summer camp or go on a vacation. Every single time I want to do something for that, I have to go to the lawyer, and the lawyer has to go to the court and petition the court for permission to spend the money.
Absolutely. In a guardianship, you're absolutely correct, David.
And so it seems, and it's been $15,000, it seems, for decades. It hasn't changed with inflation.
Nope, it's been $15,000 for quite a while. There are ways to work, I wouldn't say work around that, but there are ways to work within the system. But yeah, for the most part, you're going to need a guardianship, and you're going to need a lawyer, and it's going to go through court, and you're going to have to petition the court for all of your expenses.
And you got to pay your lawyer too. And to do these annual filings and to do the petitions to pay whatever the bills are. And sometimes when there's lawsuit settlements, it can't be helped. But I think with regards to inheritance, with proper planning, these types of guardianships can be avoided. And that's one of the things that we do, is we talk to our clients who may have minor children or minor beneficiaries about how to avoid a guardianship of a minor's property. And the best way to do this is to leave property through trust. That if someone comes and they do a trust to leave the property of their minor or the cash to their minor children or other minor beneficiaries, then they don't necessarily have to go through the process of doing the annual guardianship for the minor's property.
Oh, no one wants to actually go through a guardianship. So if you can actually plan for it, and obviously the best way to do it, one of the best ways is a trust for a minor, then you're better off. I would much rather have my estate planning done with trust for children than have to go through a guardianship and have some judge made, no offense to any judge, make decisions for my children, rather than me at least being able to make those decisions through a trust.
And plus, at the end, the child will probably end up with more when they reach the appropriate age, rather than because you don't have to pay the annual attorney's fees. And the other benefit, I think, with trusts for minors is that the guardianship for a minor's property expires on the minor's 18th birthday. When the minor turns 18, that they go in and have it discharged and distributed to the minor. Now, an 18-year-old may not necessarily be mature enough to handle the money. However, with proper planning, a trust can drag it out and hold it longer and have a trustee pay for their tuition and for graduate school and for weddings, and allow them to receive the money at a later age. But if you are in a situation where you're the parent of a minor or know a minor who's inherited a significant amount of money, or is the beneficiary of a lawsuit settlement, then you're going to need to do a guardianship of the minor. And that's something that we can certainly help you with.